So you did not go into this, Judge Walker, but your sexuality became perhaps a sideshow is a more accurate description than an issue, but it arose in the case of the marriage cases. And I wondered if I might turn to the judges on my right and left for thoughts on whether you've ever found your own sexuality to be part of someone else's agenda when appearing in your court.
Start?
Sure.
Okay. In my court, no. And really, I wouldn't say as part of anybody's agenda generally. Where I've bumped into the issue that caused me to have to kind of examine what do I do and what should my role be was really when I was Solicitor General of the state of Oregon. I headed up all of the appellate work done by 30 or so for the Attorney General's office. And I was in that position during the time period when Oregon had its own Measure 9, Measure 13 on the ballot, seeking to, they were worded differently than Colorado's Amendment 2 by quite a bit, but essentially there were provisions trying to ensure that gays and lesbians didn't have special rights, was the lingo in Oregon. And so I had to determine what my role would be in that to the extent those measures came to the Attorney General's office for defense. And in that particular case, it was kind of easy to decide. I had a full staff. I could easily withdraw my own or take myself off those cases and not participate directly on them and leave it to other professional staff I had and just avoid any controversy of it. It's not as easy to do that when you're on a court and when you're a judge. But I haven't run into it as a judge. We really haven't had any issues come to the Oregon Supreme Court involving marriage equality or other LGBT rights kinds of issues. I had one sexual harassment case when I was on the Court of Appeals that was brought by a gay man. My participation on the case was never questioned by any of the attorneys. I didn't remove myself from the case, and so it was a non-issue.
Judge Parker, any?
My orientation has not come up in the courtroom. I've not seen anyone try to use that as part of their agenda in the courtroom, which was your question. Of course, that issue came up in the context of a speech that I gave to an organization at the beginning of the year. And that is the only instance in which I have had to deal with it.
This is your internet fame.
It has been referred to in that way.
For those of you who don't know Judge Parker, she's well, I'll let you report, but she's quite widely known on the internet by those who follow these issues for what I would suggest a brave and principled position she took in a speech earlier this year.
Well, let me say, first of all, just to provide some context, because there may be some of you who are not aware, but back in February, I was invited to the Stonewall Democrats of Dallas, a LGBT democratic organization in Dallas County that works very hard in connection with the local party, and we happen to have partisan elections there, and so I am a Democrat and ran as a Democrat in 2010. In any event, they invited me to their organizational meeting in February to ask me to report on my first year on the bench. I'm in the middle of my first term and had just completed my first year on the bench, that being 2011, and so they invited me in February of 2012 to come and talk about my first year on the bench. I gave remarks that were in three parts, and the remarks began with me talking about the progress that I had made with the court since when I inherited it. It was the worst docket among the 13 civil district courts, and so I talked a lot in terms of concrete statistics of the progress that we had made that, of course, I'm very proud of, and certainly lauded my staff for their role in it as well. So we talked, I talked about that initially, and then I moved on to the second thing, which is kind of ironic given how some of this ended up. But the second issue that I talked about at length was the poignant lesson that I learned on the bench after my first year, and that lesson being that in all instances in which you endeavor to do justice, which I define as making decisions according to the laws, in that case of the state of Texas, you don't always feel as though you have done justice. That is, it doesn't feel just all the time, because even though you are applying the law to the facts in front of you, you may not agree with the law. You nevertheless are under an obligation, as you have taken a sworn oath, and have a duty to apply the law, whether you agree with it or not. And I talked a lot about the fact that as a young judge, that is a difficult and important lesson for you to learn early on, that you can't do anything to try to override how things are going to turn out because you don't like the law. You just have to apply it. That's Lady Justice in essence. And so I talked about that. And then the last thing that I talked about was the fact that I often get asked the question from people, this very question that was just asked, does it ever come up, my orientation, in the process of me carrying out my duties as a judicial officer and a trial judge? And I said, no, of course it doesn't come up in the decision making, it doesn't come up in the courtroom in terms of the way that I apply the law and what I do every day, but in as much as my orientation is a piece of who I am. And let me just, as an aside, very quickly say that you'll see that I consistently make reference to the term orientation. I use that term. The reason I do it is because it's very important to me not to affirm stereotypes that focus and pigeonhole people in the LGBT community as one-dimensional people who are sexual beings and nothing else. And so orientation is more encompassing than that. And so I consistently use that term. And so when I am saying orientation, I am referring to what people typically are talking about as sexual orientation. But I believe strongly that our orientation is about so much more than our sexuality, and so I use that term. Going back to the point, though, I mentioned in response to that it comes up in ways that, because it is a piece of who I am, it informs the way I move through the world. So as examples, I gave, number one, the instructions that I give the veneer panel as well as members of the jury to not discuss the case amongst themselves or with anyone else. Well, the instructions that we get from the Texas Supreme Court say, do not discuss the case with your husband or your wife. I inserted your husband, wife, or partner. It's certainly within my discretion as a trial judge to do that. I do it because I know the real world is that people in my courtroom have partners, not just husbands and wives. I don't want them to discuss the case with their partners either, and it's improper. So I talk about it in that way. Another example I gave is when I have jury questionnaires where we give, because we've got a large trial and we've got a sizable veneer panel, we pass out a questionnaire to elicit information from the panel about their potential biases, etc. Often the lawyers will prepare and propose the questionnaire, and they give it to me as a trial judge to modify and make a decision about what ultimately is submitted. Inevitably, the questionnaire that they give asks the name of the person's husband or wife or spouse, and then it asks what their employer is. Well, of course, I know, again, dealing in the real world, that people have partners. I also know, having served in jury duty, that there is a real conflict when you go to jury duty and you're asked the question, fill in the information related to your husband, your wife, your spouse. You know you've got a partner of, in many cases, many, many, many years, and there's something that feels weird about not completing the question. And I feel that it denies people dignity that people deserve. It invites people to not give full disclosure, which at the end of the day, what do we want to know? We want to know, is there someone close to you who has had an experience related to this trial that might impact your ability to be a fair and impartial juror? So I altered the questionnaires to insert that language. All of this is in the interest of justice, but again, what leads me to do it is I am informed by that piece of me that is gay. And so I talked about that. Then the final thing I said really is kind of an afterthought, so it was stunning to me, the reaction, is I said that I have the power to perform marriage ceremonies, but I do not perform marriage ceremonies because I live in a state that doesn't have marriage equality, and I cannot apply the law equally. Well, that statement, my goodness, wow. And this is really the first time, this is the very first time I've publicly even talked about this, because...
This is our safe space.
Well, really the reason that I'm talking about it now is because this is an academic environment. It's an experience that I learned from. I think other people can learn a lot from it as well. And also because in the media, everyone that wanted to do the interviews I knew that they were going to edit it and make it what they wanted it to be, which is what it was not, which is how it ended up being so, it was unbelievable. I can't begin to tell you. So in any event, that was the context in which I said it. Now, what's important, and this will be the final thing that I'll say about it, what's important to know is that I am a state district civil trial judge. It is not my job to perform marriage ceremonies. It is a privilege that I enjoy by virtue of the Texas Family Code, which lists the people who can perform marriage ceremonies, and a district judge is one of them. So the initial reaction that some people had, and frankly, I think some of the media people were kind of embarrassed because if I don't have to do it, it's not a story. But in any event, so initially, I think people, and rightfully, if you are a constituent and you're a Dallas County citizen, particularly if you voted for me to apply the laws of the state of Texas, if you think it's my job to perform marriage ceremonies, and you think I'm engaging in an act of civil disobedience to advance my personal agenda, of course you would be angry, and you should be, because it's improper, and it demeans the judiciary, and it demeans the integrity of our system if I were to do that. But I was not doing that. It is a privilege that I have. What's really funny, and I'll stop, is that both my sister and my father got married in the last year, and I didn't perform either one of their marriage ceremonies. And they understood why. They understood, to be serious, they understood that to ask me to perform their marriage ceremonies, aside from the equal protection issue and the equal application of the law issue, it would be like coming to me if I am barren and asking me to throw a baby shower. Culturally, we just understand that you just don't do that. It's not appropriate. It hurts too much. It's not appropriate. Anyone who doesn't get that, they're not seeing me as a human being. And if they don't appreciate that, they're seeing me as something else, but certainly not as a human being who has feelings and emotions that I have to process and live with.
Thank you. I'm curious, Judge Parker touched there on how one's orientation can inform your approach to the procedure in a trial court. And I wonder if you've had any, if Judge Walker, you have any comparable thoughts on a witness you've seen or testimony you've heard that played out differently because of things that, because of work.
Oh, I'm sure, Keith, that everybody who sits as a judge draws upon his or her experiences in life in assessing the testimony of witnesses. I can't think of any particular instance in which sexuality has affected that. But it has been interesting in my case in that I came to the bench not fully open about my sexuality, although kind of at the tipping point. And I was quite sure at the time that I went through the confirmation process that somebody would ask about it. The FBI, the Senate Judiciary Committee, somebody from the Senator's office, the White House, the newspaper person, and so forth. Nobody said a thing to me. The question was asked, and several of my friends were asked, or at least they reported to me that they were asked about it, but to my great surprise, nobody said anything to me directly. That was, of course, a don't ask, don't tell era, which remains to a considerable degree, I think, although much less so now than was true 22 or 3 years ago. But if this issue is likely to come up, it is more likely to come up in that context than I think it is after you go on the bench. The Proposition 8 case was a special case. In the 20 some odd years, or almost 20 years that I was on the bench before that case came up, and I was increasingly open about my sexuality, I fully expected at some time that I would get a call from the Daily Journal or the Recorder or somebody asking about some aspect of that. Never came, never came. And it actually never came in the course of the Proposition 8 case itself. While I was on the bench in the case, it all came later after the decision, which of course gives a certain context to the issue coming up. But I think happily we are now much more than as in the past in a situation much as Ginny described, where yes, we all have our backgrounds, we all have our personalities, we all have our life's experiences, but at least this life experience is receding very much into the background And it is much less of an issue now than it has been in the past. All much to the good, in my view.